Hi everyone, you are watching Nyaya Vimarsha, and today's video is not about whether you agree or disagree with the bail order in Umar Khalid and Sarjil Imam's case. It is about something far bigger. So how a senior advocate speaks about the Supreme Court and the judiciary on national television and whether that kind of language crosses into the domain of criminal contempt. Before we begin, so this is an educational commentary and not a legal advice, and I am going to use only the exact lines which he had spoken in two of his interviews, one in NDTV and the other in India Today. So under the Contempt of Court Act 1971, criminal contempt includes publication, spoken or written, that scandalizes or tend to scandalize, or lawyers or tend to lawyer the authority of any court. Now comes a very crucial question. So are judges above law? So are we not supposed to call out their judgment if something is wrong? Absolutely yes. But there is a line between a recent criticism of a judgment and declaring the court as something dead, lawless or finished. So now, so how a contempt can be initiated? Section 1(5) of the Contempt Act says that Supreme Court or High Court can take cognizance suo motu or on a motion by the designated law officer. For the Supreme Court, the designated law officer is either Attorney General or the Solicitor General, and if a private person can move with their consent by that AG or HG. So there are two routes to set the contempt in motion. First is the suo motu contempt by the court in itself. Second, a private contempt motion with AG or HG's consent. So now let's watch the video clip of Mr. Colin Gonsalves in NDTV.
These persons will be recognized as India's foremost freedom fighters, and the judiciary will have to reconcile with putting India's freedom fighters who fight for justice.
But what would you say? What would you, Mr. Raju, also?
So it is not a legal critic merely. So this is a moral coronation, calling under trials as future foremost freedom fighters. Even if you believe strongly in civil liberties, this kind of phrasing is reckless because it prejudges what courts and trials are supposed to determine and frames a judicial decision as if the judiciary is imprisoning the future national heroes. A senior advocate has all right to argue for liberty, but calling the accused persons, that too in an anti-terror framework, as India's foremost freedom fighters, it calls for the public interpretation. So are the terror accused freedom fighters? So this is exactly how institutional mistrust is manufactured. Now let us watch the next clip of his interview in NDTV.
If you ask me, this judgment is total lawlessness. This is, to me, after 35 years of practice, the signal of the death of the judiciary as far as human rights is concerned. It's the end of the Supreme Court. And respect and love for the Supreme Court that I had when I joined is destroyed today.
Mr. Gonsalves, thank you so much for taking the time out and speaking to us here on NDTV.
In this, he calls the judgment as total lawlessness, then says it is the signal of the death of the judiciary and end of the Supreme Court, adding his love for the court is destroyed. So who cares for that? So this is the core issue. A lawyer can say this judgment is incorrect, this reasoning is inconsistent with the precedent, or this violates Article 21. But saying total lawlessness, death of the judiciary, end of the Supreme Court is not critique of a decision. It is an attack of the institutional legitimacy of the court in itself. And such words come from a senior advocate, it carries a greater weight. So because the public sees it as the insider verdict. So this is precisely why the law defines criminal contempt to include speech that lowers the authority of the court. Now another clip for you. So this is from India Today.
It reminds me of the emergency. And it reminds me of the terror of the emergency, Indira Gandhi's emergency, where people were locked up and, lost sight of. It reminds me of the emergency because no one had the courage. No court in the country had the courage to stand up to Indira Gandhi. God knows why, but they could not stand. These are shades of an emergency. And the people who are in jail today are like all those who were in jail in Indira Gandhi's time. They suffered in jail. Many of them in the opposition in government today. They suffered in jail. And when they came out, they were treated this matter 3 times. 5 years have passed. The High Court has not even begun the matter. Reluctance to start a matter because their own leaders will be found out to be the persons who started the riot.
Mr. Gonsalves, I give the question.
In India Today's interview, he constantly says, it reminds me of the emergency. No court had the courage to stand up, and calls it as a shades of an emergency. Then there is another line which is extremely serious, where he says there is reluctance because their own leaders would be found out. So this is nothing but attributing motive on judges. So it is not at all a fair criticism of a judgment. It is you are attributing motive on the judges who delivered that verdict. So let me be clear. Contempt should not be made a tool to silence dissent, but if contempt is used for tweets, then the same yardstick must apply to national television remarks, that too by a senior advocate Colin Gonsalves. And in Prashant Bhushan's case 2020, the Supreme Court took suo motu cognizance over tweets and held him guilty of criminal contempt. So I am not saying the facts in the instant case are identical to that one. I am saying the standard cannot be selective. So if calling out the court on social media can invite criminal contempt, then publicly declaring the court's judgment, that too in a very sensitive case in an anti-terror framework, as something a total lawlessness, death of the judiciary, and Supreme Court's end, should at least invite serious judicial consideration. So I conclude with 2 possibilities. One, the Supreme Court may consider initiating suo motu contempt if it believes these statements crosses the line into the criminal contempt. Second, if a public-spirited citizen believes this meets the legal threshold, then the law permits a private contempt motion, but only with the consent of the Attorney General or the Solicitor General in the Supreme Court. So if you want more breakdowns like this, subscribe to Nyaya Vimarsha. Jai Hind.